Okay, welcome to Chapter 48, Personal Property and Bailments. We're going to be talking about primarily the use of property without a transfer of ownership, which is the simplest way you can describe a bailment, although obviously, since it's the law and lawyers are involved, we're going to make it more complex if possible. And that's, of course, just common. All right, let's go ahead and jump in to this chapter. And the first thing you have to do when you're talking about using property is define what you mean by property. So I guess one of the issues here is when you have something that we interact with every day in our lives constantly, we often don't stop to think about how complex something is, how difficult it might be to actually define what it is. So sometimes it's a little bit harder when you have some of the simplest words to give a real definition. And property is like that. So if you think about property and you really start drilling down to what it is, it's not a thing, but it's a collection of rights. So you can ask questions like, do you have the right to own this? Is this thing subject to ownership? Does it have a legal protection? So, and these are questions that are rooted in ethnocentric ideas, which is the idea that your society, your ethnic group is what is right and what is normal, and chronocentric, as it's sometimes used, which means this time is what is normal. So when we're talking about property here, and that's really the beginning of bailments, we ask, what are we talking about? The thing itself. How can we own this thing? Is it subject to ownership? And does it have any value whatsoever? So generally when we talk about property too, we divide it into two larger classes. We say it is either real property or personal property. And real property, the shorthand quickie definition of that is real estate. Also, when we're talking about real property, sometimes you'll hear the term fixtures or a fixture. So fixture is property that may have been at one point personal property, which we're going to define in 1 second, but now has been permanently attached to the land. So for example, the 2x4 that you went down and bought at Home Depot, when you bought it was personal property. But when you took it home and you nailed it up inside the attic to support the roof and it becomes a support beam, now it is a fixture, and fixtures are real property. So fixtures are personal property that's somehow been permanently or semi-permanently attached to the land and then passes with the land itself. Now the other type of property is pretty much everything else, and that's personal property. And personal property generally has a separate division, two separate categories. We talk about tangible personal property. Now, tangible personal property is property that has a separate existence and its value is determined by what it is, and that's a somewhat confusing sentence. But an easy way to think about that is just think of an object that you could lift or pick up or carry by yourself or in a pickup truck even. So you might have thought about the cell phone in your pocket, or you might have thought about your pickup truck. You might have talked about gravel, or you might have talked about a lump of coal. All those are tangible pieces of personal property. So it has a separate existence, and its value is determined by what it is. A lump of coal is valuable because it's a lump of coal. A gallon of gas is valuable because it's a gallon of gas. It doesn't represent anything else, which obviously leads us to the second larger category, which is intangible property. Now this is property that represents another thing, something intangible. And the easiest way to think about this is a share of stock. So if you think about it, if you had a piece of paper that said 100,000 shares of Microsoft, if I ask you what the tangible value of that piece of paper was, just as a piece of paper by itself, it's 1/100th of a penny or whatever a piece of paper costs you to buy. Okay, but it represents other ownership in things. 100,000 shares of Microsoft is nothing to laugh at. I'm sure it's worth hundreds of thousands of dollars. So it intangibly represents something else. Sometimes too, and this is not a separate category, but it's a term you hear. Sometimes you hear the term chattel, and that really covers almost all forms of personal property. Okay, why is it important that we make this distinction between what is real property and what is personal property? Well, the reason we have to do that is that they're taxed differently. That's one reason. So, for example, if you buy a house, you pay one type of tax by buying it, but you don't pay the same type of tax you would pay if you bought um, a soda, right? You might live in a state that has a 7% sales tax. Well, all right, you're going to pay 7 cents on a dollar soda you bought, but very few states are going to tax you at 7 cents if you buy a house for $100,000 or $200,000. So that's one reason. The other reason is different laws. There's entirely different fields of law that developed around each of these. So there's real estate law and there is personal property law. Now, to return to fixtures for a second, fixtures were personal property, as I said, but now they are attached to the land. And I'm returning to this because there are certain rules that go with them. The general rule is once you attach something permanently to the land, it becomes part of that land, and when you sell that land, okay, then that fixture goes with it. So when I sell you my house, the beams in the ceiling go with the house. Some things, of course, are not covered. Some things you can ask, well, is this just personal property that is on the house, near the house, with the house? Does it pass with it? So we can look at the traditional practice. So a quick example here. If you build a microwave in, above a stove, it becomes a fixture. But if you have a microwave sitting on the counter, it's still a piece of personal property. When I sell that house, it doesn't pass with it, but the built-in microwave would. Now, there's slightly different rules if we're talking about things that were installed by commercial tenants who are leasing real property. So if I rented a factory, the factory itself, or if I rented a store, okay, and I put in shelving or I put in a machine that manufactures something, and I'm just renting the land or renting the building, that when I give up my lease, okay, doesn't stay with the land. So trade fixtures typically don't. What we could call private or personal fixtures typically do. Okay, how do you get ownership of personal property? Well, you can get it by capture. I guess that's one way. Maybe more common in the past. You can actually catch something like a fish, or you can shoot a deer, something like that. You can also get it by finding property, and we're gonna talk about the difference between lost and abandoned property and mislaid property in just a little bit. You can get it by making it. And if we think about a lot of intellectual property, you know, an author comes up with the idea for the book. He thinks it, and then he writes it. So he produced the value, and now he owns it. It's intangible, but he owns it. Sometimes you get a gift. That's an easy way to get property. Now, gifts have their own little separate area of the law. They're treated differently. Gifts are really defined as we're going to give someone property, we're going to transfer it to them, and we're not going to get any consideration. If you get it in a will, we call that a testamentary gift. Now, there's 3 requirements for a gift. You got to physically turn the item over. You have to mean to turn it over as a gift, and the other person has to accept it. Now, there are other categories. We can talk about a gift that is inter vivos. Now, these are separate from testamentary gift. Inter vivos is a gift made while you're living, and again, the 3 requirements apply. Then there are gifts causae mortis, which is a gift made in anticipation of death. And generally, if I give you something, assuming I'm going to die in the very near future, I can revoke that acceptance if I don't die yet. And you generally have to die of what you perceive to be your oncoming death for this to cover. Not a huge area of the law, to be honest with you. We can talk about accession and confusion. Accession is when one party adds value to something owned by another party. So, you know, you own a car, and it's your car, but you leave it in my house, and I'm tinkering around with it, and I put on new hubcaps, or I put on, I put in a new headlight. Well, I don't suddenly get ownership here, okay? Generally, the owner gets control and keeps it. If, however, I've substantially increased the value, and I did this in good faith. So you left this at my house for 5 years, and after about 3 or 4 years, I took the car and I tried to track you down, and I couldn't. You were abandoned. And I put a new engine in, I put new tires on, and I put a new transmission in, and I put thousands of dollars in. Well, in that case, that accession might lead to a transfer of ownership. Confusion is when you commingle goods, fungible goods, and we can't figure out who owns what. So the easiest example of this is you have a silo of grain, and two farmers come along, and the silo holds 10,000 bushels. One farmer puts in 5,000 bushels, the other farmer puts in 5,000 bushels. Whose individual grains of wheat are they? You can't tell. Now, if it's a wrongful act, if someone's trying to cheat someone, then the innocent party could get all the goods. But if not, if it's a mistake, or if there's an agreement, you become what we call tenants in common. And we talked about the different types of tenancy ownership. Okay, I told you I was going to get back to mislaid, lost, or abandoned property. This is kind of everybody's, Saturday morning fantasy, where you find a briefcase and there's $1 million in it, and the question is, can I keep it? Well, it depends how we're going to classify that property. Was that property mislaid? Was that property lost? Or was that property abandoned? So mislaid, someone puts it intentionally and forgets it. So, someone puts down the briefcase, they forgot where they put the briefcase, they were moving the briefcase, they were taking the money from one bank to another, and they set it down and they forgot it. If you were to find that briefcase, you get no title to it. And in fact, if it's found in a location, the person who finds it, if they own it, has to make an attempt to find the owner. And he is only, the person who found it is only a caretaker under the law. Now, lost property is a little different. Lost property is property that's involuntarily left. So the briefcase falls out of the car and bounces along the road, and lo and behold, you walk up and there's the briefcase. Now, you get good title to it. So you find it, that means it's yours unless the original owner shows back up and can show it's his. Now, you should generally, if you find lost property, turn it over to the state. The state of North Carolina has mechanisms to hold on to lost property like this. And if no one comes forward and claims it, it either can escheat or estray to the state, or it can go back to the person that found it. The best instance here would be abandoned property. This is where it was discarded intentionally by the true owner. So bad guys are running away. They just sold $1 million worth of drugs. The police are trying to catch them. They intentionally throw a briefcase out the window. Now, forget for a moment the criminal law and the whole aspect of evidence and things like that. In theory, they abandoned that property. Abandoned property that's been discarded, whoever finds it gets good title. Finders, keepers, losers, weakers. This also generally covers lost treasure. So if you're digging and you find a lump of treasure that's been in the ground 100 years, generally it's yours because it's abandoned property. However, not always. Let's take a look at something that happened off the coast of North Carolina. This is an illustration of the SS Central America. It sank in the 1850s, shortly after the California gold rush, and there was a lot of money on board. So it went down with more than $100 million. I think it sank in 1857. More than $100 million worth of gold. And the question was, okay, so it disappears off the coast of North Carolina. It's down there for more than 100 years. Some treasure hunters find it. Whose gold is it? Well, is it lost? Is it mislaid? Is it abandoned? Interestingly enough, some insurance companies, after it was found, let me just jump forward a slide and give you some numbers here. It sank in 1857. It had between $100 and $150 million in gold. But some insurance companies had paid off, saying, okay, we insured this for loss. And when an insurance company pays off a loss, they get ownership in the thing that was covered. So if your car gets wrecked and they total the car, the insurance company now owns that car. So if your car gets totaled and they give you a check for $10,000 and you take the check, the wreck belongs to the insurance company. The insurance companies actually got in a lawsuit about 8% of that value. So they could show that they were the successors in interest and that they hadn't completely abandoned the property. It might have been lost property instead. So they gave them 8%, which I think was pretty generous. All right, let's move on and talk about bailments. Now, what's a bailment? Okay, a bailment is when one party passes possession of a property, but not the title, to another party who holds it for the first party. Now, that sounds pretty complex, but the simplest idea of a bailment is renting a car. If you go to Hertz or Rent-A-Car or Avis or whatever we're talking about, and you go in and you say, I want to rent a car, and they say, sure, you give us $40 a day. We will let you use this car. You don't own this car, you only use this car. So I'm passing possession of it to you, okay? The Bailor, which is Hertz Rent-A-Car in this place, is passing it to you. You're the Bailee, and you're holding it. Now, usually bailments are for the mutual benefit of each other. So there's different types, but we'll talk about the three major types of bailments in a second. So, the elements is, first of all, it only covers personal property. There's no such thing as a real property bailment. That's a lease. You do have to hand over possession. There has to be some exclusive control you're giving to the bailee who accepts control. And it can be a physical delivery, here's the thing, I'm handing in your hand, or constructive, here are the keys to the car. There is a bailment agreement, which is either express for your car company, it's going to be a contract you sign, or there's an implied one. And it should provide for the return of the property, identifying what's being loaned out and what are the fees for all this. Now, as I said, there's different types of bailments. So there's three general types of bailments, and they're kind of easy to think about. There is a benefit for the sole benefit of the bailor, there's a benefit for the sole benefit of the bailee, and then there's the most common one, benefits for each. So let's look at three different cases. I have a really sick cat. Oh, this cat is 17 years old. It's diabetic. It suffers from projectile vomiting. It also suffers from uncontrollable diarrhea. And I'm going to Paris for a month, and I say to you, hey, will you do me a favor? Will you take care of my cat and give it insulin injections and clean up the vomit and clean up the poop for a month while I'm gone? And you say, because I'm your good friend, yes, I will. And I don't offer to pay you. I'm just asking you to do it as a friend. This is a bailment because you're getting a piece of personal property. That's what the cat is. And the bailor is getting all the benefit here. I'm getting all the benefit. You're the bailee, you're getting nothing. Okay. In that case, the standard of negligence, how much care do you have to take care of the cat? You're only liable if you are grossly negligent. So if the cat gets sick, or if the cat has so much diarrhea or vomiting that it dies, and maybe you could have saved it if you had spent thousands of dollars at the vet, you have no liability. Now, bailments for the sole benefit of the bailee, a little bit different. So let's suppose you're a teenager in the neighborhood and you come to me and you say, oh, Mr. Chapman, you own a 1914 Stutz Bearcat, or you own a 1930 Bentley. I've got my prom coming up, and I cut your yard. Can I borrow your car to take my date to the prom? And I say, sure, I'm not going to charge you. You're a nice kid, Johnny. Here is the keys to the car. Bring it back safe. Now, I'm not getting anything out of this. I'm just doing it out of the goodness of my soul. You're getting all the benefit. You're getting this nice car to use, to take on a date. Apparently I'm insane. This is a bailment for the sole benefit of the bailee, you, Johnny. So your liability is very, very high. It's the absolute opposite of sole benefit of bailor. In this one, if you get one scratch on that car, you have liability. Obviously, between those two extremes, the sick cat and the Bentley, is where most bailments are. Bailments generally are for the mutual benefit of both people, and the standard is common negligence. So, what are the rights of the bailees in most of these cases? The bailee has temporary right of possession, and if anybody tries to interfere, he has the right to stop them. He has the right to use that property, makes sense. There can be some compensation. Um, you have a right to limited liability. You got to notify the bailor of any limits. The duties of the bailor, he's got to take reasonable care in protecting it. He's got to return the property. And if the goods can't be returned in the condition they were in, we're going to show, and we're going to presume negligence, although it's a rebuttable presumption. The duties on the bailee. What are the bailor? Well, the bailor will be protected while the car is in. The property is not going to be abused. That the bailee will use the property in a prescribed manner. That they will surrender it when it's over. That the bailee won't sell it. That there's no liability absent consent, no limits on liability. That if there's any service or anything like putting gas in the car, that's all up to you. So you got to notify the bailee of all known or hidden defects. If it's a sole benefit of the bailee, it's only your known ones, not your hidden ones. Bailments obviously are going to end at some point. They're not eternal. They can end by mutual agreement. Hey, can I have the car back? Or hey, can I have my cat back? You can do it on the demand of either party. Remember, and I've told you this over and over this semester, any contract can be broken if you're willing to pay the penalty of the break. So you can break a rental contract, but you might owe money to the other side. If the bailment was completed, if I had borrowed it to dig a hole and the hole's dug, it was a steam shovel. If you take some act inconsistent with the bailment, like I said, yeah, you can take the car to the prom and instead you take it to the beach, we could end it. Operation of law. Sometimes the law will say this bailment is over for different reasons. There can be some special bailments that we could mention at least. Now, these first ones were more common in the past, but you're still going to run into them. The first one is actually still pretty common. That's a bill of lading. When you ship a good, so if I put 300 tons of aluminum metal on a tractor trailer, 300 tons would be a lot of tractor trailer, on a train, the train is going to be a common carrier. They're going to give me a bill of lading, which means this aluminum is being shipped. We've got it. Okay, so that's a bailment. All right, that's a bill of lading. There can be warehouse receipts. So this is documented title. We're still talking about special documented titles. You could put stuff in a warehouse, say tobacco warehouse. You put 500 pounds of flue-cured tobacco. You would get a warehouse receipt that the goods are stored and they're in the possession of someone else, but you still have title to them. You could have delivery orders where you turn the goods over to a carrier or a warehouse. So it's either a bill of lading or warehouse receipts. Any recognized document of title can start a bailment. Now, sometimes the document of title will actually say to the bearer or to order of. And that means that the possessor of the document title is entitled to receive, to hold, and dispose of it. And the good faith purchaser of the document of title gets rights. Okay, final points here. COVID has shown us one thing, that we're getting a lot of stuff now via common carriers. So it's being delivered by FedEx, it's being delivered by UPS, it's being delivered. So publicly licensed common carriers, okay, they're going to take possession of something to ship it, but they don't own it, right? Think about it. They're not getting ownership, they're getting right of use. And that usually is a mutual benefit bailment, and they're going to have pretty strict liability unless there was an act of God, public enemy, someone blew it up, order of public authority, the government said we need this tractor trailer to get vaccine someplace, act of a shipper, the person who actually packaged it did a bad job, or in the inherent nature of the goods. If it's a warehouse, you have the regular standards of negligence. Final ones are hotels. Now we're talking about their personal property, not their person. And there's a bit of a split here. We ask, is it a temporary guest or is it someone in the regular business of renting it? If it's a lodger, a permanent residence, we got common negligence. If it's others, then generally we're going to look for a little more strict liabilities. Okay, well that was quick and dirty, I guess we would call it, at the end there. And it's about 25 minutes to half an hour. It's like what I like to keep them. And whenever you're ready, you can click on the next one.